establishing factual cause: the but-for rule and the substantial factor rule. In addition, there's a third rule which is sometimes applied. It has come to be called the alternate liability rule, and the rule comes from a case called Summers against Tice, which either you have read or you will read, because it has become quite an important case. In Summers against Tice, two defendants, this really happened, two defendants fired bullets. One of the bullets struck John and actually put out John's eye. It didn't cause John to die, but it put out John's eye. But it was impossible to tell whose bullet it was that put out John's eye. John sued both defendants. Defendant number one said, hey, you can't prove that it was my bullet. So whether you use the but-for approach or the substantial factor approach, you can't prove that my bullet was a cause. And defendant number two said the same thing, and they both made perfect sense, because after all, the burden in a tort case is on the plaintiff to prove by a preponderance of the evidence all the elements of his case. And in this case, the plaintiff could not prove that it was defendant number one's bullet and could not prove that it was defendant number two's bullet. And here's what the California Supreme Court said, and this has become a rather popular rule in other states. The California Supreme Court said, when two defendants commit identical acts of negligence, one of which causes harm, either of which could have caused the harm, under circumstances such that it's impossible to tell which one caused the harm, we will presume they both caused the harm and shift to the defendants the burden of attempting to prove that it was not their act that caused the harm. I'm going to give you those four elements again, and then we'll apply them to the facts in Summers against Tice. Two or more defendants commit identical acts of negligence. In this case, defendant number one, defendant number two, both negligently shot in John's direction. Second, one of them caused the harm. We know that one of the bullets hit John, we just don't know which one it was. Third, it could have been either of them. Well, they both fired in John's direction, and either bullet that struck John could have put out his eye. Fourth, the circumstances are such that it's impossible to tell which one actually caused the harm. And in this case, the bullet could not be identified to a particular gun. Actually, they were shotgun pellets, so it was impossible to identify them to a particular gun. And then the California court and many other courts since have said, we will presume that both of them caused the harm and shift to the defendants the burden of attempting to prove that it was not their act that caused the harm. That has come to be known as the alternate liability theory, and we're going to visit that theory again later on and see how important it has become in recent years. Just to make sure that you really understand what this cause and fact or factual cause thing is all about, I'm going to give you a hypothetical. It's silly, but I think it'll establish the point that I'm trying to make. Many years ago, my mother and father made a mistake, as a result of which I was born. Today I was driving to work. I wasn't looking where I was going, I was reading a map instead, and so I hit a person who was walking across the street in front of me, and I knocked her down, and I broke her neck. Certainly, my reading a map was a factual cause of the pedestrian's injury, because, let's use the but-for rule, if I had not been reading the map, I would have seen her, and I would not have struck her. But how about the negligence of my mother and father some years ago? Remember, if they had not made that negligent mistake, I would not have been born. Can we say that their negligence was a factual cause of the pedestrian's injury? I know there's something about that bothers you, but if you apply the but-for rule, you have to admit that the negligence of my parents in having me was a factual cause of this pedestrian's injury, because without my birth, that injury to the pedestrian would not have occurred. If you can understand that, if you can assimilate our discussion of factual cause into that hypothetical that I've just given you, you understand why we need more than factual cause to make a person liable. That's why we need legal cause, because legal cause draws a line. With regard to any harm, there may be many, many, many factual causes. Some of them we're going to make pay, and some of them we're not going to make pay. We're going to draw a line somewhere. We're going to say, look, the guy that was reading a map when he was driving, he's going to have to pay. But the person that made a mistake that resulted in the birth of that guy, hey, that was so far away, so distant in time, so distant in concept, that we're not going to make those people have to pay. That